Justice Rajakaruna, I hope my pronunciation is correct, Judge, Supreme Court of Sri Lanka, my sister and brother, judges of different high courts of this country, former Judge, Justice Jain, Mr. Jayakumar, the Registrar of Bharati Vidyapeeth, Dr. Ujjal Bhuyan, the Dean and in charge and principal of the new law school, law college of Bharati Vidyapeeth, Dr. Jyoti Dharam, the vice principal, faculty members who are present here, members of the bar, my dear students, ladies and gentlemen, a very good evening to all of you. It is indeed a privilege to be in such a great institution, Bharati Vidyapeeth. So I thank the university management for giving me an opportunity to come here to visit the university and share a few of my random thoughts with all of you. This is not my first visit to Pune. I have been visiting Pune quite often. But first visit, today I went to the bar and now in this university. I also take this opportunity to pay my homage to this great visionary, Dr. Patangrao Kadam, because of whose vision we have this great institution today. Dr. Kadam had a dream. In fact, today, before coming here, we were watching the documentary on the Vidyapeeth. In the campus, I am told there are 25,000 students. In the residents are about 25,000 in the campus. Certainly, it's a very, very big university. About 2-3 weeks back, I was there in Parul University in Vadodara. There I was told they had about 22,000 residents. So here I am, 25,000 residents. And there are 8 other campuses too. It will be much more if we count all those campuses. And the university budget, only budget of the university is 1,400 crores. So this is quite a huge university, and so therefore I'm very happy that I'm here to share my thoughts and experiences with you. Already, my previous speakers have already spoken about mooting. They have spoken about artificial intelligence, also generally about law students, also over the faculty. So I'll not go into all this. I will primarily focus within the limited time frame that we have. That's again another important aspect of lawyering, time management. Within the limited time frame that I have, I will focus on this basic topic of human rights. Now, when we speak of human rights, we often speak of Justice Krishna, undoubtedly, there's no doubt about it. Also, we speak of Justice H.R. Khanna. But we should not forget the seminal role played by Justice P.N. Bhagwati. It was he, through his very liberal and innovative judgments after emergency, post-emergency, which had opened up the entire sphere or space of human rights. I'll come to this a bit later. A couple of months back, Mr. Kailash Satyarthi, you must have heard his name, the Nobel laureate, a child rights activist, and I have been knowing him since my Guwahati judge days in 2011. He said, I would like to meet you. So I said, oh, you're most welcome, come over. So he came to my house in Delhi, and he said, my organization, this child rights organization, we are planning to have a roundtable conference in Delhi. The idea is to bring in compassion in the justice delivery, compassion in decision making, judicial decision making. So I said, I'll go. It was moderated by Justice Hima Kohli. She has recently retired from the Supreme Court. We were 10 sitting Supreme Court judges who were present there. It's not necessary to name who were there. I was also there. And we had also a large number of retired judges of the Supreme Court who were present. Justice Kurian Joseph, Justice Madan Lokur, Justice Sikri, Indira Banerjee, they were there. The idea, as I said, was to bring in element of compassion in judicial decision making. So when my turn came to speak, I said that we are now in the 75 years, we have completed 75 years of our constitution. I said, as students of law, we need to introspect. It is no good. Undoubtedly, we have traveled a long, long way, but it is no good all the time patting our own backs, saying that we have done this, we have done that. Supreme Court of India is the most powerful court in the world. It is. But at the same time, we need to introspect whether or somewhere down the line, we have gone wrong. Only if we do that, only if we introspect, then only there can be course correction. And I am sure, and I have the firm belief, there is enough room for course correction in the Indian judiciary, which we have today. As a Supreme Court judge, sitting Supreme Court judge, I have no hesitation in saying Supreme Court is supreme because it is the final court. Had there been any other court above the Supreme Court, like the Privy Council of yesteryears, many of the judgments of the Supreme Court perhaps would have had to suffer a relook. Why I am saying is this: as students of law, we need to develop a critical mindset, a questioning mindset, and not to lap up anything and everything what comes, including judgments of the Supreme Court. We need to critically analyze whether these judgments, what is this, what the judgment lays down. Of course, we know that the criticism of the judgment has to be on the firm legal basis. We have to give reasons, and we cannot impute any motive. So therefore, wherever I go, after I became a Supreme Court judge, I have received many invitations. At least 15 universities I have visited. I always tell my students that please develop a mindset which questions, a questioning mindset, and critically look at the judgments. Many of the judgments, I had said in the recent meeting of the Indian Law Institute in Guwahati, where Justice Oak was also present, we need to, the recent judgments which have come out, we need to have a critical examination of these judgments. Now, coming to the topic of the moot court competition, my previous speakers have said the importance of mooting and how well you have prepared and how well you had presented. So I must congratulate all the participants who have come from different law colleges and universities across the country and abroad. Winning and losing is immaterial, as has been pointed out. It is the experience that you will take back which is very important. As you step into the legal profession, you will soon realize that you are not going to be in each and every case that you argue. So therefore, you must be able to take in your stride the setbacks that you may face in your legal career, and that too with a smile. Friends, when we speak of human rights, I'm not going to speak about the international scenario. We all know about the Universal Declaration of Human Rights and also the two covenants, because Human Rights Declaration was not a binding document. So therefore, in 1965, United Nations had two covenants, one on the civil and political rights and the other on the cultural and social rights. India is a signatory to both the initial 1948 Universal Declaration of Human Rights as well as the two covenants. And thereafter, since it is binding, our parliament enacted the Human Rights Act in 1993. Here we have got a definition of human rights. Not necessary to go into that. And also this act provides for constitution of human rights commissions at the national level as well as at state level. Now, when we speak of human rights, it is not that after the statutory definition of human rights and the Human Rights Act which came in, that we have started having the human rights discourse in India. In ADM Jabalpur versus Shukla, Justice Khanna, delivering the minority judgment opinion, had said that rights under Article 21 is inherent in a human being because we are a human being. It is not that the Constitution has conferred such rights on us. Constitution has only acknowledged such right. It is necessary to just go back a little bit on history. In 1975, internal emergency was declared. A couple of days later, a presidential notification was promulgated prohibiting access to the courts, even for a writ of habeas corpus. This was challenged by a journalist, Shukla, in the MP High Court, Madhya Pradesh High Court. A division bench of Justices A.P. Sen and Justice Tankha, they had ruled in favor of the petitioner, saying that even when there is an internal emergency in place, the right to access the courts cannot be denied to a citizen. The state challenged this before the Supreme Court. And by a majority of 4:1, this judgment was reversed, saying that when there is an emergency in place, a citizen has got no fundamental right to approach the court to seek a writ of habeas corpus. It is in that context that Justice Khanna had made the aforesaid observations that Article 21, the right to access court, is a part of our fundamental rights, part of our human rights. It is not that the Constitution has conferred such right upon us. It was there because we are human beings. Constitution has only recognized such rights. During the course of that hearing, the Attorney General was Nirende. And Justice Khanna writes, he has written in his autobiography, neither roses nor thorns. Khanna's nephew is our present Chief Justice of India. In his autobiography, Neither Roses Nor Thorns, he has written that when this hearing was taking place on such a seminal topic of such importance, he was trying to understand the psychology of his brother judges on the bench. Either they were silent or they seemed to be tacitly endorsing the stand of the Attorney General. So he felt a little bit uneasiness. So he put a query to the learned Attorney General, Nirande. It was actually a query to his brother judges who were there on the bench. He put a query to the learned Attorney General, saying that, all right, emergency is in place now, whether a police officer without warrant can shoot a person. And the answer of very nonchalantly, Nirande said, well, when the emergency is in place, and question was shoot a person and whether the victim will have any right of remedy. The response was that the victim will have no remedy as long as the emergency is in place. Therefore, he decided that the way he was thinking, his would be a minority opinion. He beautifully, please go through this, those who have spare time, please go through his autobiography, Neither Roses Nor Thorns. MC Chagla had written Roses in December, he has written this, Neither Roses Nor Thorns. So he said, I had written the draft, I had prepared the draft judgment, and this was before Baisakhi. He requests his wife and his sister to go to accompany him to Haridwar. There's a beautiful guest house. Whenever the visitors come to me or my guests come, I always send them to that guest house. It's a beautiful guest house overlooking the Ganges. So on that moonlit night, all three of them were sitting there. And then he quietly told his wife and his sister that I have prepared a judgment. Mind you, Justice Khanna was next in line to be the Chief Justice of India. He said, I have prepared a judgment, but that judgment may cost me the Chief Justiceship of India. His wife did not say anything. His sister did not say anything. And the next day, the three of them returned to Delhi. Throughout the journey, all three remained silent. The rest, we all know, is history. Now, after the emergency was lifted, elections were held, a new government, Janata Party government, came to power. Maneka Gandhi wanted to travel abroad. But the then government impounded her passport. So she filed a writ under Article 32 in the Supreme Court, saying that I have a fundamental right to travel, which is traceable to Article 21. And the right to travel includes right to travel abroad. By impounding the passport, you have violated you have infringed upon my fundamental right under Article 21. Other grounds were also taken. We need not go into that. So, the precise question before the court, this was a 7-judge bench, subject to correction. Justice Bhagwati was one of the leading judges there. The question was, what are the contours of the expression procedure established by law as it finds place in Article 21. Now for this, we again need to take a step back. In 1950, Mr. A.K. Gopalan, he was a communist leader from Kerala. At that time, it was part of the Madras province. He was arrested under a preventive detention law. Initially, he had filed a writ in the Madras High Court, and finally it came to the Supreme Court. He challenged his preventive detention as well as the Preventive Detention Act. Primary ground of challenge was that, again, what are the contours of this expression, procedure established by law? Gopalan canvassed the point that that procedure must be just, fair, and reasonable. Today, it appears to be just passe, this is acceptable. There can't be any other formulation. But during that time, we are talking about 1950, when the Constitution was just adopted. But the majority repelled this argument. The other points also, the 14, 19, 21 are all interlinked. If there is violation of 14, it will lead to violation of 19. If it leads to violation of 19, it will lead to violation of 21. The majority said, no. All that this expression means is that there must be a proper valid law in existence. And that proper valid law must lay down a procedure. Once these two conditions are fulfilled, a person can be deprived of his life and liberty. They also said that principles of natural justice are too vague. This is trying to bring in through the back door the concept of American due process, which the Constituent Assembly had expressly rejected, that we cannot have, or we need not bring in the American concept of due process. Maybe it was the early days, as I said. The lone dissenting judgment opinion was that of Justice Fazal Ali. Justice Fazal Ali said that the law must be in conformity with the principles of natural justice. The law and the action both to meet the test of Article 21. He also said that, Then in R.C. Cooper's case, all of you may be knowing, the students of law would be knowing R.C. Cooper's case, the bank nationalization case, the first limb, that 14, 19, 21 are separate, they are islands, was repelled. This time, the Supreme Court said, all these three articles are intertwined. Violation of one will lead to violation of the other. They cannot be read and understood in isolation. That's R.C. Cooper. Now coming back to Menka, the 7 judges bench held that the law must be fair, not formal. I'll just... It must conform to the requirements of fairness, non-arbitrariness, and by extension, compliant with the principles of natural justice. Friends, Maneka Gandhi can be said to be the watershed moment of Indian constitutional history. It had unleashed the interpretive prowess of the Supreme Court. And since then, it has had the impact, multidimensional impact on our constitutional jurisprudence. Post Maneka Gandhi, we had this public interest litigation jurisprudence flowering in this country. We had the human rights jurisprudence, I'll deal with this, then environmental jurisprudence, and electoral reforms. Now, human rights jurisprudence, Justice Krishna Iyer took over, where Justice Bhagwati took over, where Justice Khanna left, and Justice Krishna Iyer took over, where Justice Bhagwati left. Right to free legal aid, you all know, right to fair trial, right to a speedy trial, have all been held to be fundamental rights traceable to Article 21. Rights of the prisoners, be him an under trial, post-conviction, or at the appellate stage. Bail jurisprudence, the famous saying by Justice Krishna Iyer that bail is the norm, jail is the exception in our country, and which 2024 in large number of cases Supreme Court has reiterated this principle. Supreme Court has also held that prisoners, just because they are prisoners, are not denuded of their fundamental rights. Certain fundamental rights, such as the right to life, pervades the prison walls. D.K. Basu versus State of West Bengal is an important case. Please remember this, in which the Supreme Court said that custodial violence, including death, is one of the worst crimes in a civilized society governed by the rule of law. Any form of torture or cruel, inhuman, or degrading treatment would fall within the inhibition of Article 21. Supreme Court also issued a series of directives what is to be done post-arrest. D.K. Basu did not stop at that. It also endorsed the line of judicial reasonings or the principles formulated by the Supreme Court since Rudul Shah, then Neelabati Behra, that in a public law remedy, under the public law remedy, persons or victims who have suffered human rights violation can be compensated, or rather should be compensated, which will be in addition to the compensation under the private municipal law. Now, two issues I will flag off, that's all. Another issue which is intrinsically connected with this custodial violence and which is concerned with human rights is the issue of extrajudicial killings. According to National Crime Record Bureau data, NCRB data, during the last 2 years, cases relating to encounter killings shot up by 65.9%. However, between 2001 and 2018, only 26 policemen were convicted for custodial violence, though 1727 such deaths were recorded in India. And this despite guidelines by the National Human Rights Commission. In Prakash Kadam, again from Maharashtra, versus Ram Prasad Vishwanath Gupta, this is a 2011 case, Supreme Court declared in no uncertain terms that fake encounters nullify the very essence of the rule of law. Supreme Court used strong words in deprecating such practice and held that if a case of fake encounter is proved against a policeman in trial, it must be treated as the rarest of the rare case and death sentence must be awarded. This is Supreme Court saying in 2011. Encounter philosophy. There are trigger-happy policemen. Encounter philosophy is a criminal philosophy. It has got no place in a democracy and in a civilized society which is governed by the rule of law. Again, on a case from Maharashtra, People's Union for Civil Liberties versus State of Maharashtra, Supreme Court has laid down standard operating procedure for extrajudicial killings. So, this jurisprudence of human rights has evolved over the years. It has also spread its wings to other branches. For example, sexual harassment of women at workplace. In Vishaka, Supreme Court said that this is violative of human rights and therefore laid down guidelines under Article 142. National Legal Services Authority filed a social action litigation in the Supreme Court saying that we need to move ahead of the men-women binary. There is a significant population in our country who are, whom we call, derisively call the hijras, the eunuchs. They are human beings. But look at their plight. So in this seminal judgment of 2015, Supreme Court said that they will be considered as the third gender and they will be equal to all the rights and liberties as enjoyed by men and women. The scourge of manual scavenging. Just imagine, in 21st century, human beings carrying excreta of another human being. So in Safai Karamchari Andolan, Supreme Court said that this type of inhuman practice cannot continue in a country like ours. Finally, in K.S. Puttaswamy, he's a retired judge, Supreme Court declared that the right to privacy is an intrinsic part of the right to life, which is traceable to Article 21. According to me, this is one of the most outstanding judgments after Maneka Gandhi. Its full impact will be seen in the years to come. Already we have seen, it has already been applied in Navtesh Singh Johar and number of cases where we have acknowledged the LGBTQ rights and number of judgments. Now, in a case relating to land acquisition, where the landowners were deprived of the adequate due compensation, Supreme Court in Lalaram versus Jaipur Development Authority, it's a case from Rajasthan, said that though right to property, you all know right to property is no longer a fundamental right, but it is still a constitutional right under 300A. Supreme Court said it is nonetheless a jealous possession of which one cannot be divested except by authority of law. Without the right to property, other rights become illusory. Right to property is now considered to be a human right. It's a human right. Friends, as students of law, in recent times, we are witnessing a very disturbing and depressing practice of state authorities using bulldozers to demolish houses and properties of persons accused of committing certain offenses. Of course, it is defended, such action is defended by the state authorities by saying that these were illegal structures either without permission of the competent authority or that they had encroached upon land of others, maybe private, maybe public. One of my most favorite quotes, and somehow which is very close to my heart, is the one which is credited to William Pitt, the Earl of Chatham, which he had said in March 1763 and quoted with great approval by Lord Denning in 1964 in a case called Southam versus Moot. The quote is like this: "The poorest man may in his cottage bid defiance to all the forces of the crown. The poorest man may in his cottage bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his forces dare not cross the threshold of the ruined tenement. So be it, unless he has justification by law." Now, this quotation has been referred to by Justice Gawai in his recent judgment in the matter of demolition of structures. It's the 2024 judgment, you will find it. He has also referred to a poem, a Hindi poem by the famous Hindi poet Pradeep. And the poem reads like this: "अपना घर हो, अपना आंगन हो, इस ख्वाब में हर कोई जीता है। अपना घर हो, अपना आंगन हो, इस ख्वाब में हर कोई जीता है। इंसान के दिल की ये चाहत है कि एक घर का सपना कभी ना छूटे।" So, loosely translated, it means that to have one's own home, one's own courtyard, is a dream which lives in every heart, and this longing never fades away. So therefore, in this judgment, Supreme Court deprecated such practice. This is unheard of. This is totally incompatible with our constitutional scheme. Supreme Court also looked at it from the angle of the right to shelter. In that house, all right, we assume that this person may be an accused or he may be a convict, but his mother stays there, his sister stays there, his wife stays there, his children stays there. What is their fault? If you demolish that house, where will they go? It is like taking away the shelter over their heads. I would add, why only them? What about the accused? What about the convict? Just because somebody is an accused in an offense or a convict, that doesn't mean that his house should be demolished. According to me, using a bulldozer to demolish property is like running a bulldozer over the Constitution. It is a negation of the very concept of the rule of law, and if not checked, would destroy the very edifice of our justice delivery system. Justice Chandrachud, in one of the judgments, one journalist, his house was demolished. So he had written a letter to Justice Chandrachud as the Chief Justice. Before demitting office, his bench had passed an order in which he says, justice through bulldozers is unknown to any civilized system of jurisprudence. Bulldozer justice is simply unacceptable under the rule of law. It violates human rights and human dignity. I will not speak about artificial intelligence, but artificial intelligence, friends, it has got positives, it has got negatives. We can use artificial intelligence to monitor violation of human rights in the country. We can use artificial intelligence to monitor functioning of the human rights commissions, whether they had responded timely and adequately to the cries of violation of human rights, violations. But there is a flip side too. There can be inbuilt biases fed into the data of the computer, which will lead to all kinds of biased results. So, plus and minus, we have to look at it and come to, it will, of course, it will require a very, very detailed discussion. It's just off the cuff, we cannot say. But at the end of the day, we are dealing with a human judge, we are dealing with a human lawyer, we are dealing with a human litigant. All three are human. I remember the late Ramakrishna Hegde, former Chief Minister of Karnataka. Elections to Parliament, elections to the State Assembly were held simultaneously. His party won all the seats in the parliamentary election, but lost the assembly elections. Same day voting. So he said, this is human mind, I can't understand, I can't read. He said, human mind is unpredictable. He said, human mind is an enigma, wrapped in mystery. You like somebody, you marry somebody. You marry somebody, you like somebody. So it's an enigma. But unlike the human mind, the judicial mind cannot be unpredictable. The judicial mind cannot be frail, cannot be fragile. There must be consistency in judicial decision making. There cannot be selective application of the law depending on the litigant before the court. The endeavor should always be to enhance our rights-based jurisprudence, including human rights, accretion to the rights, and not a rollback on the rights. I think this would be enough for the day. I thank the organizers for inviting me here to share my views. I have very strong views on human rights and liberty and free speech. And I wish all of you the very best in life. I thank the organizers for inviting me once again to share my views with you. God bless. Thank you.
Thank you so much, sir, for such